What do they teach you in law school? Ask that question to someone who's never set foot in a law school classroom. Your roommate, your parents, the person sitting next to you on a plane, and watch what happens in their eyes. You'll see it. A picture forms. Dim light. Towers of cracked leather books. Some pale, exhausted student hunched over a desk at 2 in the morning, trying to cram 1,000 court cases into a brain that's already full. Memorization, repetition, drudgery dressed up as intellect. I want to tell you something plainly, because plain is how I prefer to say things that matter. That picture is wrong. It isn't a little wrong. It isn't wrong around the edges. It is wrong at its core, and if you walk into law school believing it, you will misunderstand everything that happens to you for the first year, maybe longer. Now, I won't insult you by pretending there's no truth buried in that image at all. Law students read. They read a great deal, more than most of them expected, more than some of them think they can survive. And yes, there is memorization. You cannot escape it entirely. Certain things simply have to live in your head, ready on command. But if you think that's the point, if you think law school is fundamentally a memory exercise, a contest to see who can hold the most rules in their skull at once, you have mistaken the scaffolding for the building. And here's the deeper truth. The one I want you to sit with before we go any further. If law school really were just about memorizing fixed rules, it would be a worse use of 3 years of your life. It would be less useful. It would frankly be less fun. Because the law does not hold still. The law breathes. It shifts. It gets amended, overturned, reinterpreted, narrowed, expanded, and sometimes abandoned entirely. A rule you memorize on a Tuesday in your first year might be unrecognizable by the time you've been practicing for 5 years. So if all we handed you was a stack of rules to memorize, we would be handing you something with an expiration date stamped on the bottom, and we'd be sending you out into the world with a skill set that starts decaying the moment you walk out our doors. That is not legal education. That is not what we are doing, and it is not what you are here to learn. So let me tell you what the real value of a legal education is, the chief value, the thing underneath everything else. It is not to know stuff. Hear me on this, because it matters more than almost anything else I will say to you. The value is not in accumulating knowledge like a squirrel hoarding nuts for winter. The value is in knowing what to look for, knowing where to find it, knowing how to read it once you found it, really read it, the way a skilled craftsman reads the grain of wood before he cuts it. The value is in knowing what to do when one source tells you one thing and another source tells you something else entirely, which happens more often in the practice of law than any layperson would ever guess. And finally, and this is where all of it comes together, the value is in knowing how to take what you found and turn it into something usable, into advice, into a strategy, into something a real human being with a real problem can actually act on. Let me make this concrete for you because abstractions are easy to nod along with and easy to forget. Picture this. You call a lawyer, not about something trivial, not what time does the courthouse open, but about something with actual weight to it, actual complexity. And without missing a beat, without a pause, without so much as a breath of consideration, she rattles off a clean, confident, simple answer. Fire her. I mean that. Don't walk. Run, because what you have just witnessed is not competence. It is the absence of competence dressed up to look like confidence. A lawyer who gives you an instant, simple answer to a complicated question is not thinking. She is reciting. She has skipped the part of the job that actually constitutes the job. Real legal problems do not come with simple answers stapled to the front of them. They come tangled, ambiguous, layered with facts that cut in different directions, governed by law that doesn't always speak with one voice. The lawyer worth hiring is the one who pauses, who asks more questions before she gives you fewer answers, who tells you, let me look into that, and means it because she understands that the law deserves that respect, and so do you. You're going to hear a phrase constantly throughout law school, so constantly that you may grow tired of it, may roll your eyes when a professor reaches for it yet again. Thinking like a lawyer. I'll admit, it gets overused. Professors lean on it the way a tired hiker leans on a walking stick. Sometimes out of real need, sometimes out of habit. But underneath the overuse, there is something true and something important, and I don't want you to dismiss it just because you've heard it 100 times by October. Here is what it means, stripped of the cliché. The law, at its heart, is not about answers. It is about questions. It is about choices. It is about analysis. The discipline of taking apart a problem, examining its pieces, and putting it back together in a way that makes sense and that can withstand challenge. Thinking like a lawyer means resisting the pull toward the easy answer, the comfortable answer, the answer that feels good in the moment. It means sitting with uncertainty long enough to actually understand it rather than rushing past it to relieve your own discomfort. That is the central thing law school exists to teach you. Not facts, not rules, a way of thinking, a discipline of mind that you will carry with you long after the specific statutes you memorized in your first year have faded, been repealed, or been replaced by something Congress hasn't even dreamed up yet. Now, I don't want you to hear any of this as a dismissal of content, of substance, of the actual law itself. We absolutely want you to learn real things, specific things, things with names and numbers attached to them. Let me give you an example pulled straight from a course many of you will take in your first year, Civil Procedure. In Civil Procedure, you will learn about subject matter jurisdiction, the question of whether a federal court even has the authority to hear a particular claim in the first place, and you will learn that even when a claim, standing entirely on its own, would not satisfy subject matter jurisdiction, it might still find its way into federal court anyway if it can be joined to another claim that does satisfy that jurisdiction through a particular section of the federal code, 28 U.S.C. Section 1367. I'll be honest with you, the first time you hear that 28 U.S.C. Section 1367, it sounds like a foreign language. It sounds intimidating. Numbers and abbreviations strung together like some kind of legal incantation. And I want to tell you something that I mean sincerely. That reaction is completely normal. Every single lawyer you will ever respect, every judge whose opinions you will study with something close to awe, sat exactly where you're sitting and felt exactly that same flicker of intimidation the first time they encountered language like that. But here is what happens, and I promise you this, because I have watched it happen to thousands of students over the years. By the time you finish your first semester, by the time you've made it through that first fall, something shifts. That phrase, that statute, that once foreign string of numbers will sit at the tip of your tongue. It will live somewhere in your mind, accessible, almost automatic, not because you brute forced it into your memory through repetition alone, but because you have now used it, you have wrestled with it, you have applied it to messy fact patterns where it wasn't immediately obvious whether it applied at all. And that is how real learning happens in the law, not through memorization for its own sake, but through use, through application, through the friction of working a tool until your hand knows how to hold it. So yes, content matters, substance matters. We are not indifferent to whether you actually know things, but the content is not the destination. It is the training ground. It is the material we use to build something larger and more durable in you, a set of approaches, a set of techniques, a disposition, and I choose that word carefully, a disposition toward dealing with real problems, the kind that will let you walk into any room, face any legal question, and know how to begin. Think about what that means practically. Some of the problems you face in your career will have nothing to do with the courses you took in law school. You might never take a course on a particular niche area, and yet 10 years into your practice, a client will walk through your door with exactly that problem sitting in their lap, and they will expect you to help them. And some of the problems you face won't just be problems you didn't study, they will be problems that did not exist yet when you were sitting in these very classrooms. I want to be honest with you about this because it is not a hypothetical for me, it is daily reality. A great deal of my own work touches the cutting edge of technology, the places where the law has not yet caught up to what science and innovation have already done. I deal with questions surrounding in vitro fertilization. I deal with questions about posthumous conception, about what happens legally when a person's reproductive material is used to create a child after that person has already died. These are not questions that existed in any settled form when I was in law school. Nobody handed me a rule to memorize for them because the rule, in many cases, simply did not exist yet. The law had not spoken on these questions because the circumstances themselves had not yet arrived. And that is precisely the point I want you to take with you. The purpose of legal education is to make you into something I like to call a legal Swiss Army knife. Not a single tool built for a single job, but a complete kit, versatile, adaptable, ready for whatever problem lands in front of you, even problems nobody could have predicted when you were sitting in these seats. And if you don't already carry the exact tool the moment demands, you will at the very least know how to find it. You will know where to look, who to ask, what body of law might be analogized, what framework might be borrowed and reshaped to fit a situation nobody has faced before. That is not a small skill. That, properly understood, is the entire skill. Now, let me clear up something important because I don't want this to be misunderstood. None of what I've just described means you are training to become some kind of hired gun, someone who simply executes whatever instruction is handed to them, who applies legal mechanics without judgment, without conscience, without independent thought. That is not what the profession asks of you, and it is certainly not what we are training you to become. What you are being called to instead, what makes this profession worth the years of work it demands, is the exercise of independent judgment. Judgment on questions of law, judgment on questions of policy. You are not a vending machine that dispenses legal conclusions when the right facts are inserted. You are a thinking participant in a system that depends on people who can weigh competing values, anticipate consequences, and reason their way to a position they can actually stand behind. And the beautiful thing, the thing I want you to feel, not just understand intellectually, is that this independent judgment can take you in an enormous number of directions, and every single one of them is legitimate. Every single one of them matters. Some of you sitting in these seats will become trial lawyers. You will stand up in a courtroom, look a jury in the eye, and fight for someone who has nowhere else to turn. Some of you will go into public service, working for the government, shaping policy, protecting the public interest in ways that rarely make headlines but quietly hold the structure of a fair society together. Some of you will become deal lawyers, the architects behind the mergers, the acquisitions, the complex business arrangements that keep commerce moving and that, done well, create value for everyone at the table. Some of you will go into business through the law, using your legal training as a foundation for entrepreneurship, for leadership, for building things that didn't exist before. And some of you will go to work for advocacy organizations, fighting for causes you believe in, using legal tools in service of justice as you understand it. Here's something I want to say to you with real candor. Many of you, across these different paths, are going to disagree with each other, profoundly sometimes. You will disagree about what the law should say. You will disagree about what it currently says. You will disagree about whose interests deserve protection and whose claims deserve to prevail. That disagreement is not a flaw in legal education. It is, in many ways, the whole engine of it. Law school is going to teach you how to disagree well, how to argue in a way that doesn't just vent your conviction but actually moves another mind, how to build an argument so carefully constructed, so honestly grounded in fact and law, that someone who started out opposing you might by the end find themselves persuaded. That is an extraordinary skill, and it is one of the most undervalued gifts a legal education gives you. The world is full of people who can shout their opinions. It is much shorter on people who can convince. But underneath all of these different paths, all of this disagreement, all of this diversity of practice, there is something every one of you shares, something that holds the entire profession together. We want, above everything else, to equip you to give sound legal advice to a client who is depending on you. And for those of you drawn to what we sometimes call cause lawyering, using the law in service of a broader mission, a movement, a cause you believe deserves to win, we want to equip you to do something slightly different but related in spirit, to figure out a legal strategy first and then go find the client whose situation can carry that strategy into reality. Either way, the obligation is the same at its root. Someone is depending on your judgment, someone's interest, sometimes someone's entire future, rests on whether you have done your job with care, with rigor, and with honesty. Now, I want to widen the lens for a moment because the law is not one single skill. It is a whole constellation of skills, and you will spend your career adding to that constellation, sharpening pieces of it, discovering which ones come naturally to you and which ones you'll have to work harder to develop. There is oral advocacy, the art of standing before a judge or a jury and making your case live in real time under pressure with no script to hide behind. There is negotiation, the quieter art of finding the deal that serves your client without destroying the relationship, of knowing when to hold firm and when to bend. There is contract drafting, the painstaking, precise work of putting agreements into language so careful that ambiguity has nowhere left to hide. There is organizational design, building the legal architecture that allows a business, a nonprofit, an institution to function, to grow, to survive its own success. We will go further into this later, into the full breadth of what a legal career can ask of you. But underneath every single one of those skills, oral advocacy, negotiation, drafting, design, all of it, there are 5 core abilities that form the foundation. Every single lawyer, no matter which of those paths they walk, will need every one of these 5. I want to walk through them with you now, because this course, from beginning to end, is built around helping you start mastering exactly these 5 things. First, digest the facts. This sounds simple. It is not simple. Real-world facts do not arrive in neat, organized packages with the irrelevant details already stripped away. They arrive messy. They arrive incomplete. They arrive with some details that matter enormously and others that look important but actually lead nowhere. Learning to digest facts means learning to separate what matters from what doesn't, to organize chaos into something you can actually work with. It is the first skill, and if you get it wrong, everything built on top of it will be wrong too. Second, spot the relevant issue or issues. Once you've digested the facts, you have to know what questions those facts actually raise. This is harder than it sounds because real situations rarely present themselves as a single, clean legal question. They tangle multiple issues together, sometimes issues the client doesn't even realize are there. Part of your job from your very first year of practice onward is to see what others miss, to look at a situation and recognize this isn't just one problem, this is three problems wearing one coat. Third, determine the governing law. Once you know what questions are actually in play, you have to figure out what law actually governs them. This is where all that research training comes in, knowing where to look, how to find the controlling authority, how to distinguish between law that's binding and law that's merely persuasive, how to track down a statute, a regulation, a body of case law that speaks to the exact problem in front of you. Fourth, apply the governing law to the facts to generate arguments and probabilistic assessments. I want to underline that phrase, probabilistic assessments, because it tells you something true about the law that a lot of people outside the profession don't understand. The law rarely gives you certainty. It gives you likelihood. A good lawyer does not tell a client you will win. A good lawyer tells a client honestly what the strongest arguments are on both sides and gives an honest assessment of where the balance likely falls. That honesty, that willingness to deal in probability rather than false certainty, is part of what separates a real lawyer from someone simply performing the role. And fifth, finally, work with the client to understand how the legal analysis fits in with the client's overall interests and goals. This is the step that too many people forget, and it might be the most important one of all. The law does not exist in a vacuum. A client is not interested in a legal analysis for its own sake. They're interested in what that analysis means for their life, their business, their family, their future. The best legal advice in the world is worthless if it isn't translated into something the client can actually use to make a real decision about their real life. That translation, connecting the cold logic of legal analysis to the warm, complicated human reality of what a client actually needs, is not a footnote to the job. It is the whole point of the job. So, when you walk into this course, I want you to set aside that image of the sun-deprived student buried in dusty books, memorizing endlessly towards some far-off exam. That is not what is happening here, and it is not what is going to happen to you. What is happening is something far more demanding and, I'd argue, far more rewarding. You are being trained in a way of thinking, a discipline, a craft. You are learning to digest facts, spot issues, find the governing law, apply it with honesty about its uncertainties, and connect all of it back to the actual human being who is counting on you. That is what this course is built to start you on, not memorization. Mastery. The slow, deliberate, sometimes frustrating, ultimately transformative mastery of skills that will serve you for the entire length of your career, long after any individual statute has changed, been repealed, or been replaced by something none of us can yet imagine. That is the real education. That is what I am here to help you build.